Thank you. All right. I'm sorry that took longer than I thought, but I wanted to be sure that I had it like I wanted it. All right. First of all, I want to thank everyone for your arguments and your work in this case. I say many times, it's always a pleasure. Court is always a pleasure when you have good lawyers. It just makes things better. And everyone who's before the court today did an excellent job and was prepared. So I appreciate that. So thank you very much for that. I'm going to begin with the 21 CVS 262, the media application for release of the recordings. The court, having reviewed the evidence, the petition, reviewed the brief filed by Mr. Toddy on behalf of his clients and all the attachments thereto. The court is going to find that with regard to the media's request for release, that the media is not a party contemplated under 132-1.4G for release. But if they were, and it was appropriate to release to them, the court undertook the analysis under G with regard to release of recordings and finds that there is evidence that the release would advance a compelling public interest. There is evidence that the recording contains information that is otherwise confidential or exempt from disclosure or release under state or federal law. The court finds that the petitioner is not a person requesting or seeking to obtain evidence to determine legal issues in a current or potential court proceeding. The court finds, number 4, that it would reveal information regarding a person that is of a highly sensitive and personal nature. Number 5, that the release may harm the reputation or jeopardize the safety of a person. Number 6, that the release would create a serious threat to the fair, impartial, and orderly administration of justice. And number 7, that confidentiality is necessary at this point to protect an active internal and criminal investigation or potential internal and criminal investigation. The court therefore finds that that good cause does not exist for granting the petition of the media petitioners, and therefore that petition is respectfully denied by the court. That is my ruling. I'm going to prepare a order to that effect, and that will be prepared sometime this week, and I'll get that out to you in a formal written format at that time. All right. With regard to 21 CVS 261, the petition of the Pasquotank Sheriff's Department to release records to Khalil Farabee, who is the adult son of the deceased Mr. Brown. The court's going to find as follows, that this matter is properly before the court on the petition to release. To the extent that notice was required, notice was given by with Mr. Williams agreeing to hear the matter on behalf of his clients, but reserving his objection for lack of notice. The court has jurisdiction in this matter pursuant to GS 132-1.4A and all subparts. After hearing the arguments for the petition and the response from the district attorney for this judicial district and counsel for the respondents of all interested parties, the court finds as follows. Number 1, that the Pasquotank County Sheriff's Department is a custodial law enforcement agency as that term is defined in the statute. Number 2, that Khalil Farabee is a personal representative under 132-1.4C4, and he's a proper person to whom the subject videos may be disclosed. The court considering the factors enumerated in subsection D of the statute. Number 4, that the court additionally considers the release of the video. In addition to disclosure, which the court finds is appropriate, I've also considered release under the statute using the same 8 criteria. And the court finds that, number 1, the release is a compelling public interest. Number 2, that the recording contains information that is otherwise confidential or exempt from disclosure or release under state or federal law. Number 3, the person requesting release is seeking to obtain evidence to determine legal issues in a current or potential court proceeding. But number 4, the court finds that release would reveal information regarding a person that is of a highly sensitive personal nature. The court finds, number 5, that the release may harm the reputation or jeopardize the safety of a person by release. Number 6, that the release at this time would create a serious threat to the fair, impartial, and orderly administration of justice. Number 7, confidentiality is necessary to protect either an active internal or criminal investigation or a potential internal or criminal investigation. Based on those findings, pending completion of the investigation and any decision regarding the prosecution of the potential defendant, the court orders as follows: that the 5 body camera videos be disclosed to Khalil Farabee and his immediate family within 1 degree of kinship, and 1 attorney licensed to practice law in the state of North Carolina. That is disclosure. That the video be held from release for a period of no less than 30 days and no more than 45 days. And that that will allow completion of any investigation being undertaken by the SBI and by the district attorney's office in this county. Number 3, that the state is to notify the court when such investigation is completed, and the court in its discretion will consider at that time further release of the video based on the factors as they exist at that time. The disclosure of the video shall occur within 10 days, and the Pasquotank County Sheriff's Department is ordered to blur or redact all facial and identifying features of the officers shown prior to disclosure. That means facial features, name tags, any identifying information of those officers prior to disclosure. The court in its final order in this matter will specify the time frames within which the video may be disclosed. In viewing the video, there were certain portions of the video that were conversations between officers, between superiors. I'm going to evaluate those videos, determine which portions are appropriate for release and or for disclosure, I'm sorry, and then we'll provide that in my order so that the videos can be properly prepared to be disclosed to the family. All that to be accomplished within the next 10 days. All right, that's how I'm going to rule. Anyone have anything they want to add or ask with regard to clarification?
Your Honor, I believe there are 4 videos rather than 5.
I'm sorry, you're right, there are.
Okay.
There's 5 files, but there's 4 videos.
Okay, all right, thank you, Your Honor.
And so I apologize, you're correct. All right, anything else?
Your Honor, while sitting here, I received an order from Ms. Hale regarding our request also that went to Elizabeth City Police Department. With your determination that my clients aren't entitled to seek release under subsection G, are you dismissing that additional portion of our petition as well?
Well, I didn't hear that portion of the petition, I don't believe.
Well, I guess what I'm getting at is, if we don't have standing, we wouldn't have standing for that. And
That would be my analysis, but I mean, I don't want to prejudge it because I didn't hear that portion, so.
All right, Your Honor.
All right.
Would Your Honor consider certifying your order for immediate appeal?
I'll take that under advisement.
Thank you, Your Honor.
All right. Yes, sir.
Will you be preparing that order as well, Your Honor? I'm sorry.
Yes, sir, I
Okay.
will.
All right, thank you. Major Wally, I'm sorry.
Your Honor, Major Wiley with the Sheriff's Office. I just wanted to clarify, it is 4 body cameras. 1 body camera does have 2 videos, so it's 5 body cameras and 1 in-car camera video
Okay.
as well.
All right.
Just so we're clear on
My
that.
Okay.
apologies. Okay,
All right.
thank you, okay.
And I will specify that in my order, and I'll clarify that with you before I enter the order.
Thank you, Judge.
All right. Is there anything else that we need to take up today in this matter?
No, let's stay.
All right, again, thank you all for being here. If everyone would remain seated at this time, we're going to adjourn court and give the officers the opportunity to do what they need to do before they can make sure that you folks all get out in an orderly fashion. All right? We'll be adjourned.
All rise. Oh yes, oh yes, oh yes, this honorable court be in recess until next appointed time. God save the state and this honorable court.